With all of that housekeeping out of the way, I would like to now turn it over to our host from GRS Community Management, Sean Thompson. You've already met her once, Sean. Welcome back.
Hi, thank you, Jeff. Appreciate it. You and Danielle, thank you for sponsoring us today. I am one of the corporate trainers here at GRS Community Management, and we have been providing great, reliable service since 1989. We have over 275 associations throughout the state of Florida. So if the need arises and you're looking for a new management company, you have some questions, please feel free to reach out to us, grsmgt.com, or give us a call. Jot down this number, 561-641-8554. So with that, I'm going to turn it back over to Jeff and Danielle, and thank you again for having this class. I know there'll probably be lots of great questions, and we look forward to it.
Thank you. Great to be here. And again, thanks for inviting us. I would like to now turn it over to one of our board certified specialists in condominium and plan development law. There aren't many of those in the state, and we have one with us today from our Palm Beach Gardens office. This is all she does. That's why she's so good at it. Danielle Brennan, take it away.
Thank you, Jeff, and thank you, Sean and GRS, for having us today. So I am Danielle Brennan. I am a board certified specialist in condominium and plan development law out of our Palm Beach Gardens office, as Jeff mentioned. I am one of 9 board certified specialists in this area of law for our firm. And I am one of, I think, 25 or 26 attorneys with K. Bender Rembaum. We have multiple offices throughout Florida. Again, I'm out of the Palm Beach Gardens office, but we do have our main office in Pompano Beach and Broward County. We have an office in Tampa, an office in Winter Springs, and we do provide some office space in Miami-Dade by appointment. As Jeff mentioned, this is all we do day in, day out, is provide expert legal services for community associations throughout the state of Florida. There is not likely an issue that is going to be faced by a community association that we haven't handled for one of our associations in the past. So we are very experienced in this area of law. If your association has an attorney and you're very happy, I'm glad for you. But you can always get a second opinion on something, or if you're looking for new counsel, please keep K. Bender Rembaum in mind. We do have a lot of free resources on our website, kbrlegal.com. We have Legal Morsels and Rembaum's Association Roundup, where you can get some great information about things affecting community associations. We do try to publish and keep up to date with the articles on there. We also have a calendar of events. Jeff is always hitting us up for doing more classes. So we do have a calendar of events on our website as well, if you're interested in getting some more education and credits with K. Bender Rembaum. So as Jeff had mentioned before, there's going to be a lot of information on the slides. Again, this is for educational purposes only. We're not providing any kind of legal opinion today. If you're searching for a legal opinion, you can certainly contact your association's counsel, or if you're looking for new legal representation, you can reach out to me. We do have my contact information in the slides. I try to get to as many questions as I can during the course, but if I don't get to your question, please feel free to email me and I will answer it to the extent that I can. So let me go ahead and do a screen share.
While you're doing that, I'm going to just quickly mention that a few of you in the chat mentioned there's an echo. It's fine for me. I don't hear an echo. I have a few others have texted me on the side and said that it's fine for them. So all I can really suggest, if you're having audio issues and can't figure it out, is to try to make sure devices like your phones and or anything else you might have, they're away from your microphones, away from your speakers. Thanks, Jessica, Kayla. And if all else fails, you could always turn the volume down and activate the captions, because we do allow for the captioning to work. So that's a workaround. Danielle, back to you.
Okay. All right. So let's go ahead and get started. There's some information here about the firm, information about myself, my catfishing photo from 13 years ago. So I probably should get that updated. All right, so today we're here about the association's official records, the homeowners association's official records, access to those records, and some other topics that relate to the handling of official records. So let's first start by saying, okay, what are the official records of the association? There's a long list of items that must be maintained by the association as official records. So the statute does provide this long list. First, you're going to have copies of any plans, specification, permits, warranties that are related to your clubhouse, your pool, those facilities that are constructed on your common areas, maybe even your roadway warranties, that you guys are obligated to keep as they concern your maintenance, repair, replacement obligations. Certainly, you're going to have a copy of the association's governing documents. Those documents are your declaration of covenants, articles of incorporation, bylaws, rules and regulations, and any amendments to those documents. There's a small little note here about the association keeping an adequate number of copies of these recorded governing documents to ensure their availability to members. The recorded governing documents are typically your declaration of covenants, articles of incorporation, your bylaws, and any amendments to them. There was a blip, I'll say, in the Florida statutes, Chapter 720, several years ago, where they included rules and regulations in the definition of governing documents and inadvertently required the recording of amendments to the rules and regulations. I think the year after the legislature realized, oh, this had an unintended consequence for the change in the definition, so they removed it. So there are some associations that have recorded rules and regulations or recorded amendments to those rules and regulations. I would have a copy of those as well, to the extent that they are your current rules and regulations. But if your rules and regulations have been updated, amended after the fact and were not recorded, I don't think that that would be included with the obligation to have adequate number of copies of your recorded governing documents in order to have them for members and prospective members. Now, as far as what does adequate number of copies mean, there is no bright line rule. It really just depends on how large your association is. If you have 1,000 lots, maybe having 10 would be an adequate number. But if you have only 50 lots, maybe having a handful of them on hand would be deemed adequate. So your governing documents certainly are part of your official records. Next, we have all of your minutes from your board meetings and your member meetings. A question we often see is with regard to closed board meetings. I won't go into when a closed board meeting is required or not, but when you do have a closed board meeting, you're still going to have to be taking minutes of those meetings. And I will note that for board meetings, in your minutes, you do need to provide the manner in which each director votes. So you do need to ensure that you have that written down as far as who the person was and the manner that they voted. Next, we have our current roster of the members and their mailing addresses, lot identifications, email address, and facsimile numbers, if they've provided written consent to receive notice by electronic transmission and have not revoked that consent. So we have a lot of associations that may have an email address from their owners. Maybe they have sent management or a director an email asking a question. And then the association will take down that email address and it's like, okay, this is the email address associated with this number. And then they'll say, oh yeah, we provide notice via email. Well, you can't use that email address as a means of providing notice unless that owner has provided consent in writing to receive notice via email to that email address. So simply having the email address is not enough in order to use it as a means of providing notice for meetings. Okay? But if they have provided that consent, then the email address is going to be part of that roster for the owners. For the insurance policies, you're going to be maintaining a current copy of all those insurance policies that the association has, like your casualty insurance, liability insurance, D&O coverage. A current copy of all contracts to which the association is a party. So this is your management contract, maybe with GRS, a copy of your contract with your landscaping company. Maybe you have a guard gate, you're going to have the contract with whoever is manning that guard gate. Whoever's providing your pool maintenance for your clubhouse, or maybe you have like exercise facilities and you have a maintenance program for the equipment that's provided in there. All of those contracts where the association is a party, you're going to need a copy of those. Now, bids received by the association for work to be performed. Pursuant to Florida statute, if you are going to be spending more than 10% of the annual budget, including reserves, if you have reserves for your association, if you're going to be spending more than 10% of your total annual budget on a contract, that contract does have to be sent out for competitive bids. So once you receive those bids, even if you don't go with that particular contractor, you do still need to keep the bid as part of the association's official records. Also, your financial and accounting records have to be kept according to good accounting practices. These financial and accounting records include accurate, itemized, and detailed records of all your receipts and expenditures, and an account for each member. Because remember, the association makes its money, its income is derived from assessments against the owners. So the association is going to be levying the assessments, charging them to each owner's account, and each owner is responsible then to make payment of the assessment. So your assessment ledger for each owner is going to include, okay, this is the amount of the assessment, this is when it was levied, this is when it became due, this is the amount when it was paid, and the date of the payment, and possibly any balance that may be due. The association will also have its tax returns and will have a requirement for financial reporting and financial statements that's based upon the revenues or the income of the association annually. Even though the association usually doesn't have tax consequences, you do still have to file a tax return. So keep that in mind. You're going to need your copy of the disclosure summary. Now, the disclosure summary is provided by statute. So, and it's usually like some kind of list stating, okay, your association, you're part of an HOA, you're required to pay assessments. It's basically for new owners coming into the HOA. All of your ballots, sign-in sheets, voting proxies, anything having to do with voting by the owners has to be maintained as part of the association's official records. We'll talk more about the retention periods, but just know here, because we have it notated, that ballot sign-in sheets have to be kept for at least 1 year after the date of that vote. Also have to keep all affirmative acknowledgments. The affirmative acknowledgments pertain to assessment payments and income statements. We won't go into detail about what that is, but just note that if you're issuing income statements, there is some kind of affirmative acknowledgement required from the owners, and it's set forth in this particular statute under the Homeowners Association Act in Chapter 720 of the Florida statutes. Now, despite the long list of records that are part of the association's official records, there is this massive catch-all at the end. So all other written records of the association that are not identified above, but which relate to the operation of the association, will be official records of the association that have to be maintained by the association. So one question that we get often pertains to emails. Are emails official records of the association? Do we have to keep them? So there is no hard and fast bright line rule in place that will let us know, yes, 100% this email is part of the association official records, or no, this one is not. Unfortunately, there really isn't developed case law or any kind of statutory guidance on this issue. However, we do have some guidance from the HOA from the condominium context with the Division of Florida Condominiums, Timeshares, and Mobile Homes. So that's a particular governmental body that has the ability to hear complaints pertaining to official records for condominium associations. And through different decisions that they have made, whether it be through a declaratory statement or through arbitration decisions, the general guideline that we use is to say anything that the manager is copied on, if an email is sent to the manager, if the manager is sending an email, that's going to be an official record of the association because they are there to work and to provide services for the association. Now, when it comes to board members, if a board member has an email address that is specifically for the association, maybe it's president@sunshinehoa.com, that email is going to be an official record of the association, right? Because similar to the manager, the board member is using that email address to conduct business of the association, right? Where it gets more sticky is if a board member is using their personal email address. Now, if a board member is using their personal email address, but they're sending and receiving emails at that address through a device that's owned by the association, meaning a laptop or maybe a phone that's owned by the association that they use, arguably, more likely than not, that email is going to be an official record of the association. However, if they're using their personal email address on their own personal device, then it is unlikely that that particular email is going to be part of the association's official records. Now, like I said, it's not something that is etched in stone, but that's the guidepost that we use based upon decisions from the Division for Condominiums. For our official records retention, all of the official records must be maintained for at least 7 years, unless the governing documents of the association require a longer period of time. Arguably, you're going to be keeping your association's governing documents forever, right? Your declaration, once it's recorded, establishes your lien rights and everything relates back to that original declaration. So it's not like you're going to be disposing of your declaration after 7 years have passed, right? But that is the statutory minimum time period that it does have to be maintained among the association's official records. Again, bids received by the association for work to be performed and records pertaining to elections and other voting must be kept for at least 1 year. Now, for all of our community or homeowners associations, you must have adopted written rules governing the method or policy by which your official records are to be retained and the time period that they must be retained in accordance with these particular statutory requirements. So if your association's board has not adopted a records retention policy, you need to contact your association's attorney to get that in place as soon as possible because you guys were supposed to have done it back before July 1st of 2024 or sometime thereafter because that's when the law became effective. So definitely be reaching out to your association's attorney so that they can prepare some rules for the board to consider and adopt at a properly noticed board meeting. Again, these records retention periods, these are at least, meaning they are minimums. So, you know, it doesn't necessarily mean that after 7 years, you can dispose of something, no problem. you really need to have a policy in place as to when a document can be disposed. Now, although all of the records we discussed previously are official records of the association, not all of the records are going to be accessible to members via an official records inspection request. So the records that are protected by the attorney-client or work product privilege relating to litigation are not going to be subject to inspection by owners. And we'll talk more about what that attorney-client work product privilege is in a little bit in the presentation. Information that's obtained in connection with the approval of a lease, sale, or other transfer of a parcel is not subject to access. This may be, if your association has the authority to do this and does it, this could be a background check or a credit check. Those consumer reports are not going to be accessible to other owners. Information that's obtained in a gated community in connection with guest visits or to owners or residents. I usually call this the mistress rule. So if there's, you have a gate and the guests are logged, you're not going to be entitled to see what that log states. Any personal identifying information like social security numbers, driver license numbers, credit card numbers are not going to be accessible to owners. Here, there's an exception made for addresses that are provided for association notice requirements. As I mentioned before, if you're using email as a means of providing notice, make sure that you have that written consent from the owner to use email as a means of providing notice. Once that email, once the written consent has been provided to use email as a means of providing notice, that email becomes accessible to owners and it's fair game when making an official records request.
Danielle, I got to interrupt because this is coming up a lot.
Yes.
It'll save us time later. People are asking about emails and public records. Like one of the questions that's now come up 3 different times. Should people be saving these emails separately? Because people delete emails all the time. So should these
Yeah.
emails be saved, like downloaded and saved as a PDF, printed, file, that kind of a thing?
Yeah, you should be. I mean, like I said before, there's no actual definitive
Right.
rule in place. The courts haven't made any determination, and there's really no guidance from the statute.
So
The
basically,
only
play it
guidance we
safe.
have
If
to
you're not
rely
sure,
on are the.
sorry.
No, go ahead.
I was going to say, basically, what we're saying is play it safe. If you're not sure, just save it. Err on the side of caution.
Yeah, absolutely. And obviously, if you're copying the manager on it, or the manager's the one sending it, receiving it, that's going to be an official record. I mean, there's no doubt about that in our minds about that being an official record of the association. It's really more so when it's directors, maybe even director to director, that it becomes a little bit more gray. But if you're using it as a means of following up on, of operating the association, if that's the content of the email, better to be safe than sorry, and actually save it somewhere.
And it's for, if you're using personal email addresses, that falls into that too. So
yeah.
So Luis, that answers your question along with the other 4 people that had the same question. And it doesn't cost anything to get like a associationx@gmail.com. Just get a separate free email address for association business. Play it safe.
Yeah. I mean, you don't want to, because it's gray. Some people will argue, well, use your personal email address for everything because then it won't be an official record of the association. But what could end up potentially happening is that it determines that it is, and now you've not maintained your official records, or you've destroyed official records of the association and may have to, deal with the repercussions of doing that. So, we always like to play it safe, obviously, as association counsel.
Yeah.
But email is very tricky. And, a lot of people will use email similar to if you were having a conversation face to face and might say some unsavory things in emails that they don't want people to see.
Yeah.
So you really should always be conducting yourself in a professional manner as a board member. Because yeah, if you're putting it down in black and white, it's something that could be subject to an official record issue or be discoverable later.
No doubt. And then text messages, the same thing.
So text messages, I mean, there's really nothing to say yay or nay on that, even from a division standpoint. I think, text messages is kind of like the uncharted frontier
For now.
for now. For now. So I think arguably, maybe not, but from from our attorney standpoint, like the way that we interact with our clients, we discourage text messaging
Right.
because there's no way for us to keep record of
Right.
that as an attorney. So if we have clients texting us, we'll say, please send it to us in an email so that we have proper record keeping. I would just discourage the use of texts because we don't know what we don't know about the texting.
Okay. All right. Well, pardon the interruption. They were just we were getting slammed with a bunch of questions related to that. So
Oh, no problem. And you know what? The law is very sticky. It takes a long time for it to get jostled from its antiquated position and to catch up with technology. I mean,
yeah.
like we're just addressing emails as official records now, and it's like, 2026. Come on. So the law is very slow to catch up with technology.
Yeah.
Maybe it will one day.
Maybe. All right,
Yeah,
back
who
to you,
knows?
my friend.
No problem. Okay, so with regard to personal identifying information, remember how before I talked about an owner who sends an email in to the association's manager, to one of the board members, maybe asking a question, but not providing written consent to receive notice via electronic transmission. And let's say that an owner, some other owner, their neighbor, it makes an official records request to see all communications pertaining to, I don't know, the neighbor's request for a change of paint color, right? And maybe that email happened to be about paint color, and the association kept it with their file and produces it as part of the inspection in response to the neighbor's request. Well, that email, again, would be part of the association's official records when it's sent to management and kept with the official records in that file. The owner who's doing the inspection might see that email address there. So, there may be a question of this email address wasn't supposed to be something that this owner could access, but it is, a part of the official records. Oops, we forgot that it was there. Well, the association's not going to be liable for the disclosure of that protected information if it's included in an official record and was voluntarily provided by the owner and not something that the association requested. So even though that email address is there, it's not something that the association is going to be liable for. Though, you should really try to redact that information from your official records. I know it can be very difficult to do that, but some more official records that are not accessible to members, personnel records of the association or the management employees. And personnel doesn't mean that the management contract is not available to the owners. It certainly is. That's not personnel of the association. They're not employed by the association. The management company is retained via a contract. So it's not the same thing. Personnel literally means an employee of the association. Medical records of owners or their residents. The association, sometimes you're like, how would the association come into contact with the medical records of their owners or their residents? Well, if you're an association that prohibits or limits pets within your community, and someone is disabled and has a disability related need for that animal, they can make a request for a reasonable accommodation under the Fair Housing Act. And as part of that process, may end up providing medical records to the association for their evaluation to determine whether or not, a person is disabled or has a disability related need for the accommodation. So those medical records that the association has, they're part of the association's official records, but they are not accessible to members when making a response to a request for inspection. Finally, here are the last two bits. Last few bits here. Any electronic security measure that's used by the association to safeguard data, including passwords, it's not going to be disclosable. The association's software and operating system, which allows the association to manipulate data, is not accessible even if the owner has a copy of the same software. So, like, for example, Microsoft Word or Microsoft PowerPoint, which I'm using to do the presentation today. Those software and operating system licenses, you're not going to be able to provide those to the members. And all affirmative acknowledgments, again, this is something pertaining to invoicing and invoice statements. As I mentioned before, attorney-client privileged records are not going to be accessible to members. The attorney-client privilege pertains to any record that is protected by the lawyer-client privilege. And any record that's protected by the work product privilege. This would include correspondence from the association's lawyer. All of that is going to remain privileged. However, the board can waive the attorney-client privilege on anything, and then that document would become discoverable by the owners via an official records inspection request. So in our correspondence that we provide, even in our emails, it states that it's privileged and confidential, right? But the association's board, not the attorney, the association's board holds that privilege. So you guys can waive that privilege. We cannot, as attorneys, waive that privilege for our clients. Membership directories. I don't know how many associations still do this, but you certainly can prepare and print and distribute to the owners a directory that has the name, lot address, and all telephone numbers of each owner. However, an owner can exclude their telephone number from being in the directory by requesting it in writing to the association. And as always, an owner can provide written consent to the disclosure of other contact information, which would otherwise not be accessible to the members, like an email address. So when it comes to our rules and covenants, we know that they're official records of the association. We're maintaining them. We're having quote unquote adequate number of copies of them. But there is a fairly new requirement for copies to actually be provided to the owners, either physically, like a hard copy, or a digital copy of our rules and covenants. So before October 1st of 2024, the association was required to provide a physical or digital copy of the association's rules and covenants to every member. They must also provide a copy of any amendment to those documents once they're adopted. And the association can adopt rules that establish standards for the manner of distribution and when they're going to be providing those copies. Now, interestingly enough, in another area of the statute, when you're amending the governing documents, there's a requirement to provide within 30 days after the recording of that amendment, either a copy of the recorded amendment or notice that the amendment was adopted if unchanged prior to the vote, and provide the official record book and page. So when this statute came into play, that didn't really take into consideration that other statutory requirement. So when we have amendments that are adopted and recorded, we advise our clients to provide the copy of the recorded amendment within 30 days to comply with both the other statutory requirement and this statutory requirement. Now, if the association has a website, you are required to post that copy of the recorded amendment or the rule amendment onto the association's website. And we'll talk more about the website requirements toward the end of the presentation. But if you do post it on the website, you're not required to send a copy of it to your members. You could instead send notice to your members that, hey, we've posted a copy of the amendment on the association's website. You can go take a look at it there. And the notice can be sent via email to those owners who have consented to receive notice by electronic transmission. And you would send it by mail to all other members if they have not provided the email consent. You've heard me mention several times an owner making a request to inspect the official records of the association. Let's talk more about what that means. So it's unless otherwise provided by law or the governing documents, the official records must be made available for inspection and copying by an owner within 45 miles of the community or within the county, and within 10 business days after receipt of an owner's request. There are several ways the association can comply with the inspection requirement. You can have a copy of all the records available and put them into a room and say, have fun. Make the records available electronically through the internet. Maybe you have all of your documents that are responsive to the request posted on the association's website, so you would direct them to the website for that. Or you can allow the records to be viewed in electronic format on a computer and then printed upon request. So maybe you have all of your records maintained or some of your records maintained on a computer that's in the manager's office at the clubhouse. You can have them come sit down at that computer to look at the records that way. If the request is submitted by certified mail return receipt requested, and access to the official records is not timely provided, meaning not provided within 10 business days after receipt of that request, there's a rebuttable presumption that the association willfully failed to comply with the request. Now, rebuttable meaning the association can present evidence to state that no, there was no willful failure here. There were other circumstances at play. A member who is denied access to the official records is entitled to their actual damages or minimum damages, which would be $50 per calendar day for up to 10 days, with the calculation beginning on the 11th business day after receipt of the written request. This is a fairly new law as well. If the association receives a subpoena for records from law enforcement, then the association must provide a copy of those records or make the records available for inspection and copying to that agency within 5 business days after receipt of the subpoena, unless it's otherwise specified by the agency or the subpoena. And the association must assist law enforcement in their investigation to the extent that it's possible. Official records crimes. So these were put into effect essentially in response to a big case that happened down in Miami-Dade concerning a very large HOA and some fraud occurring. So they made a number of criminal charges, classified certain things as criminal activity. Any director or manager who knowingly, willfully, and repeatedly, meaning 2 or more violations in a 12-month period, when they fail to provide access to the official records with the intent of causing harm to the association or any of their members, they commit a second-degree misdemeanor. A person who knowingly and intentionally defaces or destroys counting records while they're required to be maintained, or who knowingly or intentionally fails to create or maintain those accounting records with the intent of causing harm to the association or to any of its members, commits a first-degree misdemeanor. And a person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or assists another to do so, commits a third-degree felony. Now, a person who has pending criminal charges for a number of these, but pertaining to official records themselves, with tampering with physical evidence, meaning the destruction of or the refusal to allow timely inspection or copying of official records and furtherance of a crime, they're not going to be able to run for the board. That's what this is saying. A director or officer who's charged by information or indictment with tampering with physical evidence is going to be removed from office. Now, the board is then going to fill the vacancy until the end of the period of suspension or the end of the director's term, whichever occurs first. But if the charges are resolved without a finding of guilt or without acceptance of a plea of guilty or nolo contendere just meaning no contest, the director or officer must then be reinstated for whatever the remainder of that term of office is. If the criminal charges are pending, then the person cannot be appointed or elected to a position as an officer or director of any association and cannot have access to the official records of any association unless it's pursuant to a court order. The association may and absolutely should adopt reasonable written rules governing the frequency, time, location, notice, records to be inspected, and manner of inspections for these official records. However, the association cannot require an owner to show any proper purpose for the inspection or to state any reason for the inspection or limit an owner's right to inspect records to less than 1 8-hour business day per month. Now we know that we have to provide them with access to these records, but what about actually providing copies of them? The member or their authorized representative, whoever's doing the inspection, they're allowed to have a portable device like their phone or a tablet or a printer. I have actually been to an official records request where someone brought a printer scanner with them. And they can use that to make copies of the official records without charge. However, if the association has a copy machine available, it has to provide the member with copies if it's limited to no more than 25 pages. If the association is making copies for more than 25 pages, then the association can charge 25 cents per page. Or the association can obviously send it out to a third-party vendor and then charge them the actual costs that's supported by the vendor invoice. The association can also charge for the costs required for personnel to retrieve and copy records if the time spent is more than a half hour and if the personnel costs do not exceed $20 per hour. And you can't charge personnel costs if the result of the records is 25 or fewer pages. Now, I mentioned before the association's website, so let's get into these requirements. By January 1st of 2025, all associations having 100 or more parcels were required to create a website or a downloadable app for the posting of the association's documents. The website or application has to be accessible through the internet and has to contain a subpage or portal or some other protected electronic location that's inaccessible to the general public and can only be accessed by owners and employees of the association by username and password. And once the owner makes the request for the username and password, then the association has to provide that information to them. Now, behind that username and password in that protected area is where you're going to be posting the the official records that are required to be posted on your website, which would include the governing documents of the association, the current rules of the association, any executory contracts of the association that are current, meaning the association is a party and has some kind of obligation under it, or the owners have some kind of obligation under it. And once the bidding has been completed, then you also need to post a list of the bids that were received by the association within the past year. You're also going to post the annual budget, and oddly enough, I don't know why the statute says this, because there probably aren't very many associations out there that require owners to consider a budget at the annual meeting, but if they're going to be considering a proposed budget at the annual meeting, you're going to be posting that as well. The financial report and any monthly invoice, income and expense statement to be considered at a meeting. You're posting that on the website. The association's current insurance policies, the certification of each director must be posted. Any contract which could be a conflict of interest would be posted on there as well. Notice of board meetings, including the agenda, and any document that's going to be required for that meeting must be posted no later than the date required for the notice. Generally speaking, that's 48 hours notice. Otherwise, if you're adopting rules regarding parcel use or you're levying a non-emergency special assessment, that's going to require a 14-day notice. When it says any other document required for the meeting, let's say that the association's board is adopting a budget. You're going to be posting that proposed budget, or if they're adopting rules regarding parcel use, you're going to be posting those proposed rules together with the notice of the board meeting on the association's website. Similarly, you're going to be posting notice of any membership meeting at least 14 days before the meeting. It does have to be rather conspicuous. You either post it in plain view on the homepage, or you have a separate subpage that's labeled notices, which has got to be really visible on that homepage. Now, if the owners are voting on a particular document at that meeting, that document has to be posted on the association's website at least 7 days before the meeting. I don't know why they made a difference between the 14-day notice and the 7 days for the documents to be considered by the members at that meeting. I always tell my clients, just post everything together. The association has to ensure that the information and records which are not accessible to owners, which we discussed previously, are not posted on the association's website. If there's protected information on those documents that are required to be posted, then you need to ensure that that information is redacted before you post it. However, the association is not going to be liable for disclosing protected information unless that disclosure is made with a knowing or intentional disregard of the protected or restricted nature of that information. All right, so we've come to the end of the presentation, and I think, it actually took me longer than I thought it was going to take, surprisingly.
Well, I
So
interrupted a lot too. So.
No worries, no worries.
But so yeah, we do have some time left. I know, Danielle, you love to answer some of these questions, and we will do that before time for another interruption. Have some coffee.
Mhm.
We want you to hang out for the Q&A. This is good stuff. What's about to happen is some good information. We're going to answer a bunch of your questions, but the required part is over. Once Danielle got through the slides, which she did, and then we already placed the link for the evaluation in the chat module, not the Q&A module where you're asking your questions, but in the chat module, and I'll do it again in just a moment. So if you haven't already pressed the chat button, press it so the chat module appears on your Zoom interface. I'll place the link in there once again. You'll click on that link. It'll open up in your browser. You fill that out, you submit it. After you submit that evaluation, the required part is over and you are free to go if you choose to leave and not stay for the Q&A. Okay? So I'll do that again in just a moment. And after you submit that evaluation, the confirmation screen of a successful submission has a bunch of links, including the contact information for GRS and for Danielle and the firm. But it also has a link to download and save the slides that Danielle used instantly. So you're definitely going to want to fill out that evaluation, even if it wasn't required, but we need you to do that for the credit. Back to you for the Q&A. And Sean, anybody from GRS, if you're here, if you want to come back in and show yourselves, that's entirely up to you. But maybe you have some questions as well for Danielle.
Thank you, Jeff. Thank you. We appreciate it. Yes,
Sure.
Please feel free to answer any questions in the Q&A.
Okay.
Time allows.
So there are some questions on here that aren't necessarily related to official records.
Right.
For those who are wanting some guidance about assessments, using gates, I would encourage you to go to one of our certification courses. I know it's a longer course, but it will provide you with a lot of more information about those particular topics than is discussed during the record keeping. Let me see here. This is an interesting question about board members having to go through the same steps as members to request official records or documents from the management company. I like this question because Board members are obviously going to be privy to things that are attorney-client privilege where owners would not be, right? And it is part of the board members' fiduciary duty, that duty of care, to be kept abreast of all the information that is available to them in order for them to make informed decisions, right? That's part of the exercise of your fiduciary duty. Now, to the extent that a document would need to be reviewed in order for you to satisfy that fiduciary duty, I think it's fair game for you to ask the management company and not have to go through whatever formal process you have in place for owners to make records requests. But if you're requesting something that is outside the scope of what you are doing as a board member, then I would say you need to comply with the same process. Like maybe you're the neighbor of the person who painted their house a color that you don't care for, and you want to understand what's going on with that. That would be something that's motivated by you personally and not as part of the exercise of your obligations as a board member. So, it's a judgment call depending upon what the issue is. But I like that question. Okay. You know what, this is interesting too, and maybe we should put this into the presentation about the turnover of records. There is a requirement for when board members and committee members are outgoing, they need to turn over records at least, within 5 days or something like that of leaving their position. I think if they don't, then you have the ability to go after them for them. Unfortunately, it's going to be a matter of, would it be subject to pre-suit? It would probably be subject to pre-suit mediation and then litigation. There's not going to be an avenue for the association to make a complaint like a condo would be able to make an administrative complaint to the division, and then the division could come after the president. But fortunately or unfortunately, sometimes it's a mixed bag when it comes to the division, but you don't have the division at your disposal. So it is something that you would have to end up litigating if it's not something that gets settled at mediation.
There was another common theme in the Q&A earlier. Excuse me. Like, let's say you change management companies and the old management company loses the records or what have you. And I know you touched upon that already, but what I want to throw in as well, storage costs nothing. I mean, for $40 a year, you can buy 250 gigs from Google Drive. It's always good to back stuff up, your association, and back stuff up as a second layer as to what is on the website or as to what your management company might have. I know this would never happen with GRS, but some folks have falling out with their management companies, and humans can be humans. People, egos get in the way sometimes. It happens. So sometimes people do things out of spite. So it's always good to have the records backed up somewhere that you can access should you have a falling out with whomever is managing your records at that point in time.
Yeah, and as a precursor to that, if your association records are all in paper, I strongly suggest that you have somebody either volunteer or you reach out to a third-party company to have those records digitized. I mean, we're really moving toward a more digital age under the law. I mean, I understand that the law takes a long time to catch up, but
20 years,
it
20
really
years.
makes the process much simpler when you're responding to an official records request to say, oh, these records are available on the association's website. You can access the association's website with this username and password. It really does make a huge difference for management and for the board. It makes it so much simpler to do.
And Jessica, I see your chat. I will get your information to Danielle via email right now.
Can the association charge up to 25 cents per page for copies if the condo docs? Okay, so if you're in a condo, condos are very different when it comes to costs, in that Chapter 718 does not state a dollar or a cent figure for charging copies for records. If you're in a condo, then you can charge reasonable costs. Now, we would usually use the HOA Act as a fairly good guidepost as to determine what's reasonable. But if your documents are silent, yeah, you could still charge, but just be consistent with the statute. This is an interesting question. Would a member take copies via smartphone or tablet only by taking photos, or must they be allowed to connect their device to the host computer with a cable? The statute doesn't really address, like, if I bring a hard drive and I'm looking at something um, on a computer to connect the hard drive and like drag and drop. It really only mentions it as far as like doing it the way that you're suggesting, taking photos, like scanning it in that way. I think arguably you would allow it. Because they have their device there, but that's not necessarily a device that is contemplated under the law. You could always, in lieu of allowing that, have it emailed to them or have it copied, like reduce it down to a hard copy.
The problem with that is that, I mean, I'm not an attorney, folks, and Danielle will scold me if I say something I shouldn't. Okay, so keep that in mind. But the problem with that, being our quasi IT nerd here, is that allows somebody to easily retrieve confidential information, and the host computer person wouldn't know you're doing it. That's allowing somebody to physically hook up. You don't know what their intentions are. You don't know what kind of bot they may have in their device to pull information, and you wouldn't know what's happening. So that something should be addressed in the law with that. I'm surprised it's not.
Yeah, it's not, it really isn't. And a lot of things, particularly in the HOA context, aren't, because so many things get resolved in mediation, and there really isn't much in the way of case law that sets a precedent for us to rely on, which is why you hear me talk a lot about, okay, well, in condo land is this, and we use this as our guideposts, but that's not something that's necessarily going to stick in the courtroom. So few of these things don't go to court, and that's really the way the system is designed, is for association and the owners to resolve things outside of court. And that's why we have a pre-suit mediation or process in place, for people to hash out their differences in a more informal setting.
Mm-hmm.
So, but the downside to that is, well, then we don't have these things litigated, and we don't have any kind of decisions to give us that more concrete guidance.
Yeah.
So, I obviously don't want to encourage litigation, but it would help me in my job.
No, it's just that particular question, man. There's a reason why there's an owner side of the website and a public side of the website. That, to me, that's the same thing. You're letting somebody hook up to your private. That doesn't make sense to me. There should be something. I'm surprised that that's not addressed, whether it's condo, HOA, or co-op. It doesn't matter. You just shouldn't allow that to happen.
I think that there are other ways. Must you? I would say it's probably not a must. I think you would still, because there are a number of ways that you can comply with the official records request, I don't think it's a must. That's why I also think it's so much easier to have everything digitized and posted onto a website to say, okay, now you just go here and you can download it on your own.
Yeah.
Certainly makes the process so much easier.
Absolutely. Absolutely. Again, sorry for the interruption, but that one hit a nerdy nerve, so to speak.
Okay, so for associations with less than 100 parcels, is there an obligation to provide information such as requested meeting minutes without having an actual records request for the information, which for our association means via mail? I'm not sure what they're asking. all associations, regardless of their size, are required to keep official records and are required to provide access to those official records within 10 business days of receipt of a written request for access. It's just that associations having 100 or more parcels are required to have a website and to post certain documents on that website, and can then say, oh, go to the website to retrieve these documents to the extent that those documents are posted on the website. Now, that's not to say that associations with less than 100 parcels can't have a website. You certainly can. But regardless of size, you need to maintain your official records and provide access to those official records, timely access to those official records to those who are making requests. Now, I will also say that if an owner makes a request for, I want to see all, financials pertaining to costs for the clubhouse roof for the past 10 years. That doesn't mean that the association's manager or the owner volunteer who's on the board has to sit down with the official records, go through everything, and then find that record and send it to the owner. That's not what the law allows. You can just provide them with all of the records and say, hey, sit in a room. You can go through the records yourself. There's no legal requirement for you to cherry pick those records and then send the owner a copy. Remember that the statute requires that the association provide access to them, not that the association provide the records that are requested. So you have to provide them with access so that they can inspect and copy the records. Also, if they're requesting something that is not kept in the ordinary course of the association's business, like we've seen requests where owners want records pertaining to how much money they spent over the past, let's say, how much money did you spend on the clubhouse roof over the past 10 years? Well, we don't have to generate a record to respond to that request.
Yeah.
If we don't keep it, we don't have to produce it. So, it's really up to the owner to go through the records and find the information that they're looking for. It's not the association's job to do that. Now, can the association do that? Yeah, sure. I guess the association could do that, but then you risk the possibility of missing something, or, you risk the possibility of creating an undesirable precedent for your members.
Hey, Danielle, Sean over at GRS has a question. Sean, you want to come
Sure.
on in and pose your question?
Hey, thank you. Actually, we have a question from Beth.
Hi. Actually, Danielle, you kind of just touched on it briefly. We get obviously a lot of records requests here. I handle some of the records requests here. So as you can imagine, we get some crazy requests. And my question was, the official records are pretty, they are pretty obvious. And my question is, where do you draw the line? Because the residents ask for very specific records that we don't have, or it would require, let me say, it requires us to generate special reports that are not in our normal course of business, or they're not like or a financial report that would not be in our financial, or a special report that would require me to print a report and then break it down a particular way for them. And when I say no, or we get a lot of pushback and a lot of, they'll, accuse us of, not providing the records, or they'll complain to the DBPR and they want to,
If they're in an HOA complaining to the DBPR, good luck to you, because the DBPR is not going to do anything for the HOA.
They always threaten us, and and it's, so I always want to make sure we're doing the right thing, but where, and then, so you mentioned about the catch-all at the bottom of the official records. Yeah. So it's like, where do you draw the line with what you can provide?
You can only provide what you have. And like I mentioned before, you don't have to go through the records to comply with the statute of providing access to the records. You could simply just have the records available and let them look through everything. I know it's in our nature and certainly in GRS's nature to want to be as accommodating as possible to the owners. But my suggestion would be to resist the urge. You don't have to go through all of the records. You don't have to respond to those types of demands. You just say, here are all the association's official records. You're welcome to inspect and make copies. If they ask you questions during the inspection, there's no legal obligation for you to respond. And I know it's really difficult to not want to respond, but you could simply say, I'm just here to monitor the official records request. I'm not here to answer any questions. I know it's tough and I know it sounds crass sometimes to some people, but better to say nothing than to say something that could potentially bite you or your association later.
But it's okay to say that I'm not able to run a special report that wouldn't be in a normal course of business for us. If it's not,
I would just simply let them know that record's not something that's kept in the ordinary course of business.
Okay. Okay.
And I'm just going to reiterate. Oh, you're very welcome. Were you finished? I'm so sorry. I thought.
Oh, yes. Yeah.
Okay.
Thank you.
I just want to reiterate, I had a question in the chat not related to the course material. We can log off now and still get our credit. I'll just repeat that as long as you fill out the evaluation, yes, any class we do, the Q&A is bonus. You're not required to stay for the Q&A. Danielle, back to you.
Mm-hmm. Let me see here.
And we have about 5 minutes left in the advertised time. So, Danielle, you do as many as you can or choose to.
Sure. So there's a question here. Is it acceptable for a member reviewing docs to take a photo of it if they don't want to pay for copies? Absolutely. Like I've said before, that I have been to a records inspection where someone literally brought their tabletop printer scanner, put it on the table, plugged it in, and started making scans and copies of the documents that they wanted. They are 100% able to do that, and the association can't charge them for it.
Yeah.
So, yes, and it was a while ago. It was a long time ago. I'll say it wasn't as email use wasn't as prevalent back then for responding to requests, but
it's crazy. We're all walking around with portable TV studios in our hands. It's crazy.
I know. Yeah. Let me see. If you have records that date back past the required 7 years, are you still obligated to produce them if they are requested? So if you have the records, produce them. Provide access to them. If you don't have a policy regarding disposal of the records, don't throw your records away. Only dispose of them after you've adopted the policy and, dispose of the physical record. Maybe you still want to keep an electronic copy of it, and you still always have the record, but you don't have to have the electronic copy either, so long as you have the policy in place. I would not dispose of a record where no policy is in place, because again, the statutory period is a minimum. It's not a maximum. So that's the minimum amount of time that you keep it. I think once you have adopted that policy, which again, you're required to do so pursuant to law, you should have had that in place already. Then you can consider disposing of records.
Let's say the website legislation comes out on July 1, 2024. That's when all HOAs, I'm making it up. Obviously it's different, but let's say July 1, 2024 is the date that it is now mandatory that all HOAs with X amount of homes have a website. The records that have to go on that site, is it anything that takes place from that date forward, or must they put everything that's been that they have in their records from before that as well, before that date of the mandatory website?
So obviously it's a mixed bag. When it comes to your when it comes to your governing documents, you're going to be posting all of your governing documents
right
from the beginning of the association forward. When it comes to board meeting notices and membership meeting notices, I would say that that's a
Financials.
go forward. That's a go forward requirement. Um, you know, financial records, I think you should go in the past as well, and
As far
not
back as you
just
can, right?
prospective. To the extent that you can. Contracts, we're only focusing on contracts that have current obligations. We're not thinking about contracts that have already terminated.
List
Even though those,
a list or the
yes,
actual contract, because through the legislation, it's confusing. It says list all the contracts. So do you just list them, or do you have to have a link so that you can view them?
depends on the contract. So if it's a contract that may present like a conflict of interest of like a director, you're posting a copy of that contract. Um, the ex, ex executory contracts, meaning contracts that are signed by the association, I think you do have to post a copy of that contract. Now, when it comes to bids, it's a list. Trying to think what other contracts it mentions on the statute or there are two that are listed that are like conflicts, but one is expressly conflicts and the one before it is a much longer list, and I have to go back to see exactly what it says because my brain is blipping right now. But those you would need copies of the contracts.
Okay. Yeah, it came up a couple of times. So thank you for that, and pardon the interruption.
Okay, let me see here. You know, it's interesting. A lot of people are asking questions about, you know, records that must exist but can't be found. In the condo statute, there was a fairly recent update about using, you know, commercially reasonable efforts to find or recreate documents that were lost or destroyed. That obligation wasn't added to the HOA Act. So, I mean, there's no statutory requirement, but if it's something that the association doesn't have, you know, potentially there's liability for the association because it was a record that was required to be maintained. And I feel like a lot of associations end up in this rut when it comes to meeting minutes. A lot of their minutes are something that was generated by a management company, and the management company has come and gone, and they've not turned over the records, or, you know, they keep them for so long and then destroy them, and it hasn't been turned over to the association and nobody's thinking about it. I think you would still want to use commercially reasonable efforts to have those documents retrieved. You'd be surprised at what these computer companies and techie people can do when it comes to recovering data that's been deleted. You think you've deleted it, but you really haven't. It exists somewhere.
You got that right. All the more reason you don't want people hooking up to your machine directly. Dang it.
Yeah, so I think you still use commercially reasonable efforts to get those documents back. Does that mean that you have to spend a godzillion dollars? No, I really don't think so. That's not a good way to spend your association's money.
Right.
And again, for our HOAs, which this is what this course is geared for HOAs,
Right.
you don't have that agency, the division, DBPR division, who can hear administrative complaints pertaining to official records. So this is really going to be something that's going to have to be brought before the courts. So it's not as easy for owners to have access to recourse against the association for these matters. I'm trying to be very careful about the way I say that.
Understood. You want to do,
All right.
I'm leaving this up to you. You want to do one more?
I will do one more. Let's see.
One more for good measure. And then, folks, after Danielle does this last question, if anybody's struggling still with the technology of the evaluation, I'll remain on for a few minutes and help you out. So Danielle, go ahead. Man, you're the one who taught, and I'm the one losing my voice.
Oh, okay. So I'll end on this one. after turnover, is the developer supposed to provide the association with plans, specs, and permits, or are we supposed to get that from the county? The developer is required to provide you with those documents, the association with those documents upon turnover, and I think the outside date is 90 days. So that is something that the developer is required to provide to the association. You do not have to get that from the county. Typically, like when we do turnovers and assist with turnovers, we'll put together a checklist that both the developer and the association, the board, the owner controlled board will sign off on to evidence that these documents were in fact turned over to the association upon turnover. So with that, thank you all very much. Thank you, Sean, GRS, for having us. And I'm sure we'll work together very soon.
Yes,
Jeff, thank you as always.
Thank you
Yes.
too.
All right,
Well,
everyone.
All right.
Bye.
Have a great weekend, everybody. Thank you. And Danielle, before you go,
Yes. Yes.
one person posed a question here that I think we can answer that everybody would be interested. Are there any changes coming in the near future from Florida? And I think that person is referring to legislation in the most recent session. And I guess we can say with a smirk, we don't know what the hell we're going to teach next year, right? Because there's nothing.
Yeah,
At least
there
not
really isn't anything. Interestingly enough, I came across one HOA change. It had nothing to do with official records. It was about architectural control and how the association or the architectural control committee cannot require that copies of permits be provided as a condition of issuing approval, of association approval. That was like the only thing I saw coming out of this legislative session.
Yeah.
So, they didn't do anything. There were a lot of things presented, more so for condos, that were not passed this particular session. But, this may just be the quiet before the storm.
Yeah.
And 2027 may be a big year. So we'll see what happens.
Yeah, maybe they're listening to suggestions of the lobbyists and are taking their time to think these things through before just throwing these things out there and then having to fix them afterwards, because that
Right.
that happened a lot. So.
That happens a lot. And case in point, the one I discussed earlier, when they changed the definition of what constitutes governing documents, they added in rules and regulations, not realizing that, oh, hey, somewhere else in the statute, we require that amendments to rules and regulations be recorded. And now we're requiring essentially that rules and regulations, which have never been required to be recorded among the official records of the county, are being recorded. So, and then they had to remove it from the statute later. And the other blip that I discussed is, they have a requirement that copies of the covenants and rules had to be provided to the owners, and those amendments had to be provided to the owners or notice that the amendment's been posted on the association's website. Meanwhile, there's another section, it's in 72306, that requires that within 30 days of recording an amendment to the governing documents, you have to either provide them with a copy, or if the amendment wasn't changed prior to the vote, provide them with notice that it was recorded with the official record book and page. Well, those two things don't really jive with each other, and we have to make them jive. So that's why I usually tell my clients, okay, listen, you're providing a copy within 30 days or a notice that it's been posted on the website.
Yeah.
Yeah, and with the whole CEUs thing and the condos, and there were so many things that could have been, it was very reactionary to the tragedy that happened.
Right.
And so things were put into place to try to avoid that in the future, but made quite the impact on the constituency, which, was clamoring for it, but wasn't done in a really thoughtful way by the legislature, which they're trying to peel back now, but or at least provide some relief with the funding of it. At any rate, another conversation for a different day.
Another day.
But,
on top of that, and the education requirements for HOA board members when condominiums are a much more complex structure. It's bizarre. But
yeah, well, that happened because of that
I know.
very large case that happened down in Miami. You get a few bad actors, bad things happen, and then the legislature reacts. They get a knee-jerk reaction, and that's what happens, and that's why we have all those criminal charges for the official records issues
Yep.
and election issues. So
Yeah. So just move to a
anyway.
condo and then you can steal whatever you want, right? I mean, it's crazy. It's crazy. Crazy. All right. Now I'll let you go. I just needed to get that off my chest. So, Sean and Danielle, take care, and we'll see you next time.